Greetings, 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 greetings. I am King Clifford Jefferson, a Senator Godfrey, the fifth Caliban Jew, the son of folk, the ruler of Jerusalem. I'm the reincarnation of King Edgar the Peaceful, which we know here at the English Third Temple Church of England as the Vicar of Christ, or Malachi Zodok, known as the King of Righteousness. It is October 13th, 2024, which is equivalent to the Berber year 2974. I greet you in the name of my Queen, Sister Galveston, from the House of Galveston. I greet you in the name of Archbishop Belmont from the House of Beaumont. I greet you in the name of all our ancestors, predecessors, successors. I greet you in the name of the children, the mothers, the fathers, and all those who are striving to get an understanding of what it is that we are here and called to do here at the English Third Temple Church of England. This is a beautiful lesson that I have prepared for you today, and the name and the topic of the lecture is called Common Recovery, Intestate, and Escheat, the Crown Remedy. Once again, Common Recovery, Intestate, Escheat, the Crown Remedy. Okay? Once again, Common Recovery, Intestate, Escheat, and the Crown Remedy. We must comprehend those terms in order to keep along with what's going to be the topic discussed in today's lecture. Okay? As always, when I'm doing my lectures, I always like to expose those who are claiming to be standing for truth, but actually standing for falsehood. Right now, you're looking at the only channel that really knows anything about your inheritance, how it came to be, how it will be conveyed, and how it would be preserved. Okay? So all of you who are listening to all those channels out there claiming to know anything about some type of inheritance that was promised to you, you need to go back and check your teachers. Okay? As you will see in one of the videos, one individual from, I guess, or assume he's a Moor, hit him with a question in regards to the only way he would have got that term from is me, in reference to us as a nation of people. He asked the same question in regards to something that we taught about on our lectures, and he had no idea of what it is that the term meant, especially when you claim to know something about property law, real estate law, and inheritance. Okay? I'm not kicking shade on the brother, but I'm going to let you hear it for yourself. Somebody must have been watching our channel in regards to the MS Roll 1066, as well as the twig and turf ceremony. And that ceremony goes back to the kings of Wessex, starting with Asselton, Noble Stone. Okay? So without further ado, let's get on with this lecture. And you have a choice to make today in regards to if the inheritance will be returned to you or if it will be taken from you. Okay? So let's get on. One of the greatest teachers out there is Taj Tariq. All right? If you only know, everyone needs to listen. This is the house of awakening minds. The house of awakening minds. So he's supposed to be awakening minds. Okay? He's supposed to be awakening minds, the minds of the people. All right? He has 38.7 thousand subscribers. 38.7 thousand subscribers on their platform. Okay? Greetings, Countess Middleton. Once again, 38.7 subscribers, forgive me, 38.7 thousand subscribers on the platform. Grand Sheik Tajiri Bay, Grand Sheik Tajiri Bay, and Dr. G. The title of the platform or the lecture is called If You Only Knew. Now, I'm not going to go through the whole lecture. I'm just going to go to where it really counts. Okay? He gives you all this stuff about knowing how to protect your estate. Okay? When the very term in regards to how the state was given to you, he had no idea of what it meant. Okay? Now I'm going to break it down to you and show you what it means, show you where it derived from, and show you how it pertains to you. Okay? Listen very closely. And it got 14,000 views, streamed 8 days ago. It got 14,000 views, streamed 8 days ago. And if this many people watch this stream and it got that many subscribers on this channel, and for him to claim a lot about the information that he gives on this channel, and when the very question in lieu of what he speaks about on that channel depends upon if he have knowledge about what he speaks on the channel, he does not understand the question. Okay? Let's get to it. Now they ask him for a donation, right? Gifts, grants, all right? Anything that they can give to keep this movement alive. I'm not asking you for anything. It's your if you want to give, it's on you. The law says you must give. It's called free and common soakage to the king. All right? And that law will be fulfilled. Okay, but these people are taking you for everything that you think, everything that you have, and everything that you deserve. Let's see it for yourself.
Yeah, my baby can read. So yeah, so there and then there, of course there's also the more let me read where's my brand? Since somebody asked about homeschooling. Where is that? Oh, where you see it? Where is she? Here we go. There's a online with where she gets to Bay and Moorish homeschool. Yeah, for children. Yeah. Mm-hmm. Everybody's looking for that. Okay. All right. Right. Love to you from Trinidad. Let me see. Can you? Okay, no, you said that. Thank you so much. Thank you. Thank you. All right. Thank you. Which is the best etymology dictionary? I know I got one right there. You see that right there? The barn, hard, concise. But you know what? Etymon. Go to Etymon online. But right now, ETYMONON.
Let me back it up some.
Etymon. I think it's Etymon.
Yeah, I got to go back. I apologize. Let me go back some. Let me back up. We actually passed it. All right, here we go.
PayPal us. You can even send a money order if you want to the House of Real Awakening Mind and made out the House of Real Awakening Mind. But if you, but the thing that I'm talking about, if you, I think that particular document has actually been on there for at least maybe a year and a half or two. So I'm not trying to make you buy it if you bought one of them last years. Okay, I'm gonna be, because you're like, no, but I just need you to look around on there and look in the folder, and it's got somebody's name on there, and there's a lot of stuff in there, and you can crack some stuff. But look, I'm giving them up. I'm giving them in. But anyway, you need to do that. So yeah, so anybody that wants to, so anybody wants to. Another thing that's coming up, and I'm just gonna put it out there because maybe you will support us, but the website, we have when we do the unfiltered, that costs us like almost 3,000. It's almost 3,000 a year, and the payment's due in December. So if anybody wants to help us, because like I said, we don't even. The only way we're bringing in anything right now is flash, because USB drives.
They're trying the best. They're trying the best.
And we did, and we were grateful. I'm put out there. It was about a little over 700 notes came in for Friday. That Friday, and some people even gave more, than that. So, but we don't have anything coming in to us. So we're not rolling in. We don't have Patreon, and we don't have whatever they call whatever super chats and stuff. If we don't get anything from YouTube. So yeah, Zelle, you see it running there. If you House of Reawakening Minds at gmail.com, or this number, which is different, 302-983-0136. That's our Zelle number for the House of Reawakening Minds. And so yeah, but yeah, so I need to, how often do you update? I only update the drive when I get new material on it, and I'm going to say that I haven't updated. I probably haven't added anything in about 6 to 8 months, and it may be 1 or 2 things. And so I would suggest necessarily getting it. If you got one in the last 2 years, I just say look in 1 or 2 of the folders that you may not have looked at if you don't know what I'm talking about. But they're good for everybody to have, and they wear out eventually. Sometimes even the ones that I use to make the masters, I have to put the whole stack of masters.
Yes, and answer that because actually the principal
outside the USA, is it?
Yes, because it's all over the world.
Okay, yeah, and then there's so Arcel again, House of Reawakening Minds at gmail.com, or 302-983-0136 is the phone number. Either way, it'll come up with that's our Zelle. And somebody did send us a Zelle. I was like, one individual said what you said. Yes, we use PayPal. You see it running across the screen. It's paypal.me/Nyla Gilliam. Or you can, if you want to make a donation or anything to us, or you want the flash drive, USB drive, just text, say donation link or flash USB link to our 302-345-0500. Y'all know that number. That's the number. If you send me a text, I'll send you the link. We have a donation.
Y'all listen now.
Specifically purchasing the USB drive. Yes, we do use PayPal. They took the cash check. Okay. Mailing address. I'm going to say this, and then you're going to have to play it back. 602 Vandever, V as in Victor, Andever Avenue, Wilmington, WILMINGTONDE for Delaware. Zip, don't put zip exam because I want it to get to me. 19802. A lot of times people will send stuff and then they want me to send it and they want me to put stuff, brackets and all that. I can do that, but the post thing won't go through. So
they're blocking. They know their obligation. They know their obligation, but again, like I said to you, Dr. Kidd, you know why they're doing.
What's it? So can Escheat do a live about the hundreds of Delaware 100 rolls and the twig and turf ancient rituals? You know about that? I don't know what that is. I don't know.
He said you have to clarify that. I'm gonna repeat that again. Now he said, "Oh yeah, let's repeat that again." These are the people who's supposed to know about law. I gotta play that again because that's funny.
302-983-0136 phone number. Either way, it'll come up with.
Somebody hit them with a question they had no idea. They must have been watching our channel.
Yes, we use PayPal. You see it running across the screen. It's paypal.me/Nayela Gilliam. Or you can, if you want to make a donation or anything to us, or you want the flash drive, USB drive, just text, say donation link or flash USB link to our 302-345-0500. Y'all know that number. That's the number. If you send me a text, I'll send you a link. We have a donation link. We also have a link for specific purchasing the USB drive. Yes, we do use PayPal. They took the cash check. Okay. Mailing address. I'm going to say this, and then you're going to have to play it back. 602 Vandever, V as in Victor, Andever Avenue, Wilmington, Wilmington, for Delaware. Zip. Don't put zip exam because I want it to get to me. 19802. A lot of times people will send stuff and then they want me to send it and they want me to put stuff, brackets and all that. I can do that, but the post thing won't go through. So
they're blocking. They know their obligation. They know their obligation, but again, like I said to you, Dr. J, you know why they're doing it.
What's it? So can Branchie do a live about the hundreds of Delaware 100 rolls and the twig and turf ancient rituals? You know about that? I don't know what that is. I don't know.
You have to clarify that.
You got to clarify that.
I don't. Parking is awesome.
You cannot. All right, that's where we're gonna stop at. She asked him, did he know about the twig and turf ceremony? Somebody asked him, did he know about the twig and turf ceremony? And something else about a roll. Okay. That's the question that was asked. Now, this is supposed to be a scholar that you all go to, especially when questions like that. They got that device, that drive they got with a whole bunch of documents on it with common law remedies to help protect your estate. But don't no one know what that word twig and turf ceremony, which is a common law term. It's called lottery of season. Okay? So for all those who watching that channel and listening to this fool, shame on you. Shame on you. All right? Let's go take a look at this term so you can be properly educated. I'm going to play this video again before we close out. Council militant, you should be familiar with this term. Lottery of season. Everybody hold hold it for a second. Get that word out. All right. Lottery of season. Lottery of season is an archaic legal conveyancing ceremony formerly practiced in feudal England. Okay? So whoever that gentleman was, or whoever that lady who asked the question, whoever was who asked the question about the Twig and Turk ceremony, they must have been watching our channel because we're the only one, especially with our ethnicity and complex and characteristics, know about this term lottery of season, which they say is an archaic legal conveyancing ceremony. All right, glad you're familiar with it. It's an archaic legal conveyancing ceremony formerly practiced in feudal England at the time of William the Conqueror and other countries following the English common law, no other common law, used to convey holdings and property. Okay? So if he knows about property and how property is inherited and how it's conveyed, he should understand this term. The term lottery is closely related to, if not synonymous with the word or the term delivery, used in some jurisdiction in contract law or related to law of deeds. The oldest form of common law provided that a valid conveyance of feudal tenure and land required physical transfer by the transferor to the transferee and the presence of a witness of a piece of the ground itself, and its literal sense of a hand-to-hand passing of an amount of soil or twig, key to a building or that of land or other some not token. Okay? Everyone please understand that. Everybody who watches Taj Tariq show or House of Waking the Minds, please somebody tell them that. There's only two varieties, livery of law and lottery of season. We didn't get ours through lottery of deed. We got ours through lottery of law because it was promised by people who are considered dead to those who are considered living. All right? So we didn't need a will. It passes by what we call operation of law. Okay? Operation of law. Lottery of season could refer to either lottery and deed, whereby the parties met together on the land and the transfer symbolically delivered possession of the land by handing over a twig or a clump of earth to the recipient. This is all English common law. Lottery law, whereby the parties went within the sight of the land, and then the transferor declared that the recipient that possession was being given, followed by the recipient then entering unto that land. So this is somewhat like a promise. Okay, I promise you that when you go there, that land will be yours. Okay, an inheritance, not a contractual agreement with two parties who probably don't even own the property. Okay, we're gonna get into that. Twig and Turk ceremony, same thing. The same question they asked Taj. Okay, the same person they asked Taj in regards to this ceremony called the Twig and Turk ceremony, because they must have learned it from us. The Twig and Twig ceremony dates from the feudal era, but was used regularly in what? The early colonial Americas, allowing the English and Scottish after the Treaty of Union of 1707, when England and Scotland united by virtue of their monarch's claim to take sovereign possession over unclaimed land. This is called crown land, or what we call under his jure regalia, his radical title. The process has taken several forms over the century. Everybody hear that? Taj cannot break this down like this, nor can any other channel break it down like this. William Penn used this ceremony called the Twig and Turk ceremony. Are you from Pennsylvania? Probably drew past this sign. The Twig and Twig ceremony dates from the feudal era, but was usually regulated, as I said, in the early colonial days in America between the English and Scottish after the Treaty of Union of 1707. According to Marsbury, he described the process at least which originated in Wiltshire, well, not originated in Wiltshire, but a process that was in the process in Wiltshire, all right, which stated that the lucky newcomer goes unto his giving acre, okay, and cut a turf from the selected site and drops 2 shillings in the whole maid. The high steward of the county then twitches him with a twig and sticks the twig in the turf, i.e., the plot of land that was taken out. Then hands it to him, saying, "This turf and twig I give to thee, as free as Asherton gave to me. I hope a loving brother thou wilt be." Then the high steward then takes the money out of the hole, and the new landowner replaces the turf. Once again, the high steward of the county, i.e. shire, pardon, let me read it again. The lucky newcomers goes to his given acre and cuts out a turf from the selected site and drops 2 shillings in the whole maid. The question becomes, who are these newcomers? Are they heirs or foreigners? Okay? If they're heirs, then they will understand the history going back to Ashelton, the son of Alfred the Great, the kings of Wessex. If you understood the process called the twig and turf ceremony. Taj did not understand the process of the twig and turf ceremony by way of library of season. So how do you claim to have an estate here? Because everything was based upon the common law. The common law. It says the high steward of the county then twitches him with a twig and stick, and the twig and the turf, then hands it to him, saying, "This turf and twig I give to thee, as free as Asherton gave to me." The high steward then thou takes out in parts of, and I hope a loving brother thou will be. So you once again, you have to be family. You hear me? You have to be family. You have to be an athlete of the blood. All right. Under the feudal system, all land belonged to the monarch and was therefore either held by him directly, the road then designate, or on his behalf directly or indirectly. Y'all better listen to what's being said. Those who held land directly on the king's behalf were known as tenants in chief. So that means you had a landlord overseeing you. All right? It was called his lordship versus Lord Paramount, which represents the crown. If you watch my past lecture, you will understand those terms. When a tenant in chief died without an heir, his lands is ceded to fell into the hands of the king. I repeat, when a tenant in chief died without an heir, his land is ceded to the king, meaning fell into the hands of the king. If there was an heir that the king kept the land until lottery of season took place, meaning delivery of the possession, the right of possession to convey the land, which means that's the definition for the word property. The heir paid a sum of money, a relief to take lawfully and assume the possession of the land. This is what all of you are doing right now as a result of what the state of New Jersey or any other state are allowing as a result of their exceeded power, which only resulted from intestate, meaning that there were no English heirs going back to Asherton, okay, the son of Alfred the Great. All right, we must comprehend. So if there is no heirs, then the land is exceeded. Once again, if there was no heirs, the land is ceded to the crown until lottery of season can be done. And it's only done 2 ways, by lottery of law and lottery of deeds. Those who stole it by lottery of deed. Those who are going to take it back, do it by way of what we call lottery of law. Okay? All right. Let's get into this. What does escheat mean? Escheat. Escheat, which is Latin extradere or fall away. It's a common law doctrine that transfers the real property of a person who has died without heirs to the crown or to the state. Okay? To the crown or to the state. So one of the land is transferred to either the crown or to the state, whatever state you're in. When the state has it, it's called abandoned property. Bana Baker Tenia. It's called abandoned property. Bana Baker Tina. It serves to ensure that the property is not left into limbo without recognized ownership. It originally applied to a number of situations where a legal interest in the land was destroyed by operation of law, so that the owner of the land reverted to immediately the superior feudal lord. So the legal interest in land was destroyed by operation of law, so that the ownership of the land reverted to the immediately superior overlord. Etymology. The term escheat derives ultimately from the Latin ex cadere, to fall out, be a medieval French esquire. The sense is of a feudal estate in land, falling out of possession by a tenant into the possession of the lord. Okay? If it was a lord, or if there's no lord, then it must revert back to the lord premier or lord paramount, which we know is the crown. In feudal England, escheat referred to a situation where the tenant of a fee or a fief died without an heir or committed a felony. So the only way land can be escheated in two ways: either you commit a felony or the tenant died. Okay? Either you committed a felony or a tenant died. In the case of such demise of a tenant in chief, the fee reverted back to the king's demise permanently when it became once again a mere tenantless plot of land. That means the land became allodial. Okay? If there's no tenure on the land remains allodial. All right? So it says, the fee reverted to the king's damnation permanently when it became once again a mere tenantless plot of land, but can be recreated as a fee by an enfeoffment to another of the king's followers. You hear that? Okay. Where the deceased had been subinfeudated by a tenant-in-chief, the fee reverted temporarily to the crown for 1 year and a day by right of primary season, after which it is ceded to the overlord who had granted it to the deceased by enfeoffment. From the time of Henry III, the monarchy took particular interest in the seat as a source of revenue. Everyone understands that. What is primary season? Primary means first possessor. Okay? First possessor. All right? We must comprehend. At the Norman conquest of England in 1066, all land of England was claimed as a personal possession of the William the Conqueror under a allodial title. When William the Conqueror had the land, it was under the allodial title, but under feudal lord. Okay? Under feudal lord. The monarch thus became the sole corporation, sole owner of all the land in the kingdom, a position which persists to this present day. He then granted out to his favorite followers, who thereby became tenants in chief under various contracts of feudal land tenure. Okay? These are estates and land. Such tenures, even the highest one of feudal barony never conferred ownership of the land, but merely ownership of rights over it. That is to say, ownership of the estate and land. Such persons are therefore correctly termed landholders or tenants. Hence that word, landholders. Once again, I repeat, landholders or tenants, from the Latin tenio, to hold, not owners. If held freely, that is to say by freehold, such holders were heritable by the holder legal's heir on the same contractual agreement as done by the heir that died, okay, based upon how he received it from the landlord or the tenant in chief. On the payment of the premium term feudal relief, i.e., to the treasury, such heir was entitled to the demand reinfeasement by the king with the fee concerned. You must understand these terms. You must understand these terms. So, as they said, that the tenant in chief, once they died, it reverted back to the primary season of the monarch, who holds it until its library of season can be conveyed, okay, by the two forms, library of law and library of deed, okay. Now, why are you making this or speaking about this, King Clifford Jefferson? Why are you talking about? Because they said the tenant in chief is called the fief holder. Didn't they say that? Where is it at? Where is that word at? Right here. Landholder. Okay? Landholder. We must remember this term. Landholder or freeholders. Landholders or freeholders, now called the commissioners. Okay? Watch my lesson that I did previous to this in regards to the freeholders stole the plantation of the land. When you watch this one, you will be able to make the connection. Okay? Let's move forward. So we understand what Escheat means. Now let's go to New Jersey Assembly Bill 2507. New Jersey Assembly Bill 2507. Everybody hold that thought. I'm giving you facts. Okay. State of New Jersey. You see it for yourself. Introduced June 6, 2002. These are the sponsors of the bill. Synopsis clarifies and expands categories of property which may escheat to the state, reduces time for unclaimed property to escheat to the state. We understand that under the common law, the land was supposed to convey to the crown. Under civil law, it conveys to the state. So actually, the state is stealing the land. The state is stealing the land. There's no other way to look at this because the crown owns the land. We know what the word escheat means. We just defined it, right? It's either the state or the crown. The state is not the crown and the crown is not the state. All right? We must comprehend. The crown operates under the common law of England because escheat is a common law term. Okay? It's not a term created by the state of New Jersey. It originated from the common law through what they call lottery of season, which originated from the common law, which is where the twerk and twist ceremony originated from, which is under the common law, which Todd Sharik had no idea, nor do the state of New Jersey have no idea, because why? They do not study. Okay? They do not study like we do here at the English Third Temple Church of England. Okay? So you deserve what you get. Let's read it for ourselves. An act concerning the escheat of unclaimed property to the state, amending and supplementing Chapter 30B of Title 46 of the Revised Statute. It being enacted by the Senate and the General Assembly of the State of New Jersey. Y'all better listen to the one I'm telling you. They covered 8 tracks. New Jersey Revised Statute 46:30B1 is amended to read as follows. This chapter should be known and may be cited as the Uniform Unclaimed Property Act of 1981. The Uniform Unclaimed Property Act of 1981. New Jersey Revised Statute also has Section 2, Section 3, and Section 4 of Title 46, Section 3 of the Uniform Unclaimed Property Act, all dealing with the right of the state to unclaimed property that had escheated to them by way of it being unclaimed. Okay? Revised Statute 46:30B-4. Effects of this chapter on duty of a holder to report. You hear that word? Holder, landholder, freeholder. Effects of this chapter of the holder to report, pay, or and deliver property under prior law. What prior law is that? The common law. Okay, this was a assembly bill presented in 2002 in regards to amending what laws in regards to property escheated to the state. But they do honor the original form of law that originated prior to this enactment, and that conveyance or that form of remandment was still at play, as it's just said here. This chapter does not relieve a holder of a duty that arose before the effective date of this chapter to report, pay, or deliver property. A holder who did not comply with the law in effect before the effective date of this chapter is subject to the applicable enforcement and penalties provisions that then existed, and they are continued in effect for the purpose of this section, subject to revised statute 4630B-89. However, after the effective date of this chapter, the interest and penalties set forth of Article 34 of this chapter shall be assessed against the holder, i.e. freeholder, i.e. commissioner, i.e. landholder, for the failure to report, pay, or deliver the property presumed abandoned in accordance with the prior statutory provision. Why? Because they all know it belongs to who? Everyone say it, the crown. Okay? The crown. Let's look at some definitions. (46:30B6) of revised statute of New Jersey. In this chapter, the definition shall be as said. A. Administrator means the treasurer of the state of New Jersey, any individual serving as acting treasurer in the absence of the appointed treasurer, and any state employee to whom the treasurer has delegated authority to administer the provisions of this chapter to execute any pertinent document. B. Impertinent owner means the person whose name appears on the record of the holder as the person entitled to the property held, issued, or owned by the holder. Remember, the holder is the one, is the landlord or the tenant in chief. If the tenant in chief died, then it reverts back to the original owner, and that is the one who's recorded on the record. All right, and we are recorded on the record as the crown. Okay. C. That's point 39. Banking organization means any bank, trust company, saving bank, safe deposit company, private bank, or any organization defined by other laws as a bank or banking organization. D. Business association means non-public corporations, joint stock company, investment companies, business trusts, partnerships, or unincorporated associations for business purposes, or two or more individuals, whether or not for profit, including a banking organization, financial organization, insurance companies, or utilities. Joint ventures, limited liability companies, self-deposit companies, safekeeping depositories, financial organizations, insurance companies, mutual funds, utility, or other business entities consisting of one or more persons, whether or not for profit. You hear that? That means they include everybody is subject to the Escheat law that existed prior to the creation of this Assembly Bill 2507. Okay? We must comprehend. Domicile. Domicile means the state of incorporation of a corporation, and the state is the principal place of business of an unincorporated person. By itself. F. We at F. F. Financial organization means a savings and loan association, buildings and loan association, credit union, saving banks, industrial banking organization, trust company, safe deposit company, private banker, or any organization defined by other law as a banker or banking organization. So all those who claim to be private bankers, you're in a world of trouble because you don't have the power under the law to be able to take by way of one of an owner. Okay? Because the only person who can do that is the crown or the state, and you don't supersede the state. Only the crown supersedes the state because it was the crown who gave this charter to the state. That's why it was called a temporary government or what they call a provisionary government. Y'all better start reading. G, holder. This all applies to you as well. You're nothing more than a holder of somebody's estate that you will allow to have possession of by way of easement, which is a non as a possessory right and property that you don't own. That's only because of the eminent domain power of the state, which they got through what they call prescription of sovereignty. Okay? How many of you know what these terms I'm throwing at you? Do Todd understand these terms? But look how many followers he's leading to hell. Okay? And 9 times out of 10, you're going to be one of them. Okay? Financial organization or partnership. G. Holder means person, wherever organized or domiciled, who is in possession of property belonging to another. 2, a trustee, or 3, indebted to another on an obligation. That means a contract. Okay? A contract. H. Insurance company means an association, corporation, fraternal, or mutual benefit organization, whether or not for nonprofit, which is engaged in providing insurance coverage, including accident, burial, casualties, credit life, contract performances, dental, fidelity, fire, health, hospitalization, illness, life, including endowments and annuities, malpractice, marine, mortgages, sureties, wage protection insurance. Now we got I, intangible property, includes, but not limited to, money, checks, drafts, deposits, interest, dividends, and income. credit balances, consumer overpayments, security deposits, refunds, credit memos, unpaid wages, unused air tickets, undefined remittances, stocks and other intangible ownership, interest in business associations. All this stuff is unclaimed property that reverts right back to the state because it's not claimed by the original owner. Okay? Money deposits to redeem stocks, bonds, coupons, and other securities, or to make distribution. Amounts due and payable under the terms of insurance policies. Amount of distribution from the trust or custodial funds established. Remember, when they create these so-called adhesible contracts, it's pretty much a take it or leave it. Okay? It's take it or leave it. If we don't like the deal we throw at you, then no deal at all. Y'all better comprehend what I'm throwing at you. Okay? Under a plan to provide health, welfare, pensions, here you go. Under a plan to provide health care, welfare, pensions, vacation, severance, retirement, death, stock purchases, profit sharing, employee savings, supplemental unemployment insurances, or similar benefits, deleted by amendment. Now pending before the legislature as this bill. So all that stuff that was running and sanctioned by the temporary government is now under scrutiny based upon the Assembly bill established in 2002, and that has now become law based upon New Jersey Revised Statute 4630B1, all the way through all the other statutes that were amended in lieu of that. Okay? You must comprehend about what's about to take place. J. Last known address means a description of the location of the parent owner sufficient for the purpose of delivery or mail. K. Owner means a person having legal or equitable interest in property subject to this chapter. Did you hear that? Did y'all hear that? Most of y'all probably didn't because you didn't understand what Escheat means. Okay? As a result of you not knowing what Escheat means, you didn't understand what they just said. Owner means a person having a legal or equitable interest in property subject to this chapter, or the person legal representative, and includes but not limited to a depositor in the case of a deposit, a beneficiary in the case of a trust other than a deposit in a trust, a creditor, claimant, or payee in the case or other intangible property, or a person having a legal equitable interest in property subject to this chapter, or his legal representative. And guess what, y'all? I am the representative of the Crown. Person. Person means an individual, business, association, state, or other governmental subdivision or agency, public corporation, public authority, estate, trust, two or more persons having a joint or common interest, or any other legal commercial entity. Now, why is this important? And why am I reading this? Matter of fact, let me read the next one. M. State means any state in the United States. Did you hear that? Did you hear that? It didn't just say the state of New Jersey. It said the state means any state of the United States, district, commonwealth, territory, insular possession, or any other area subject to the legislative authority of the jurisdiction of the United States. N. Utility means a person who owns or operates for public use any plant, equipment, property, franchise, or license for the transmission of communication or the production, storage, transmission, sale, delivery, or furnishing electricity, water, steam, or gas. Matter of fact, I'm going to keep going. It goes down to minerals, y'all. Let's read it. Minerals. This is O. All concerning the state of New Jersey and the Assembly Bill 2507 that was presented to the Senate and the General Assembly of the state of New Jersey in regards to the right of mistreatment of abandoned property. Okay? Of abandoned property. And yes, these elements, or i.e. organic elements that originate from the earth, are abandoned property. Let's read them. Minerals means gas, right? Oil, coal, or other gaseous liquid, and solid. Hydrocarbon, oil shale, cemented material, sand and gravel, road material, building stone, chemical raw material, gemstones, feasible and non-feasible ores, colloidal and other clays, steam and other geothermal resources, or any other substance defined as mineral by the laws of this state. You hear that? All this is up for grabs through the treatment power. All this is up for grabs. Mineral proceeds means amount payable for the extraction, production, or sale of the minerals or upon the abandonment of those payments, all payments that become payable thereafter and include but is not limited to the amounts payable for the acquisition, retention of mineral leases, including bonuses, royalties, compository royalties, shut-in royalties, minimum royalties, and delay rentals. Do y'all hear what I'm telling y'all? Do y'all hear what I'm telling y'all? Now, why is this important? Let's go. Let's get there. Do I want to read any more? Let's see. You can just pull up the Title 46, column 30B, and read all the statutes yourself, and they'll tell you what they are. But I want to go to one specific statute of Title 46, 30B, since Title 46, 30B1 is the actual statute in regards to abandoned property or bona vacatina in regards to escheatment. Okay, let's read 46 colon 30B-9. The most important thing about this statute. Revised statute 46 colon 30B-9 is amended to read as follows. When property is subject to custody, all right? When something in custody is in it's abandoned property or unclaimed property, unless otherwise provided in this chapter or by the statutes of this state. Intangible property is subject to the custody of the state as unclaimed property if the conditions raising a presumption of abandonment under Article 2 and 5 through 16 of this chapter are satisfied, and the conditions under revised statute 4630B-10 are satisfied. The common law doctrine of bona vacatia should remain viable with respect to unclaimed property not covered by this chapter or another statute of the state. I repeat, the common law doctrine of bona vacatia should remain viable, which means effective with respect to unclaimed property not covered by this chapter or another state statute in the state. Now, what's important about the statute? You notice they got in brackets intangible property. Okay, and then say real property. They say intangible property because they already know the real property is already protected. It's the intangible property that's in question. Why? Let's go to the revised statute to prove it. Like it, love it. You love it, share it. New Jersey Revised Statute 4630B1. This chapter should be known and may be cited as the Uniform Unclaimed Property Act. Okay? The Uniform Unclaimed Property Act, which is nothing more than the right of New Jersey to escheat property that is abandoned. All right, you read it from the Assembly Bill, and it's not in its entirety, but in the syllabus. Okay. Short title. This chapter should be known and may be cited as uniform unclaimed property. All right. Why is this important? Why is this important? Let's go here. Section 9. when property is subject to custody. When property is subject to custody, unless otherwise provided in this chapter or by other statute of this state, property is subject to the custody of this state as unclaimed property if conditions raising the presumption of abandonment under Article 2 and 5 through 16 of this chapter and are satisfied, and the conditions under revised statute 4630B-10 are satisfied. The common law doctrine of bona vacatina should remain viable with respect to unclaimed property not covered by the chapter of another statute of this state. So why is this important? Let's go back to the bill. This bill is the bill that governs the right of the state of New Jersey to take hold of property through escheatment. Okay? Through escheatment. All right. So you see it in the Assembly Bill 2507, and you see it manifested in the actual revised statute presently as you see it today. All right. As you see it today. Now we know escheatment power originated according to the common law, right? Escheatment means falling away is a common law doctrine that transfers real property of a person who has died without heirs to the crown or to the state. Okay? So if you see this word escheat in New Jersey, and you know New Jersey has a statute for abandoned bona vacatia, which means that the property is unclaimed. Why? Because the crown has now received the property. Right? The crown has not received the property. How we know it? Let's just see. The crown. What is the concept of the crown? The concept of the crown took form under feudal system, though not used this way in all countries that had this system. In England, all rights and privileges were ultimately bestowed by the ruler. Land, for instance, was granted by the crown to lords in exchange for feudal services, and they in turn granted the land to lesser lords. One exception to this was common soakage. Owners of land held in soakage held its subject only to the crown. Okay? Only to the crown. Let's see. All right. When such lands became ownerless, though, they are said to escheat, i.e., return direct ownership of the crown, i.e., crown lands. Bona vacatina is the raw prerogative by which unowned property, primary unclaimed inheritance, becomes property of the crown. Did you hear that, y'all? So what is crown land? Most of us here know this terminology. Tashari does not know this terminology, but yet trying to act as if he got an interest in this estate. You have none, buddy. Crown land. Crown land, also known as royal domain, is a territory area belonging to the monarch who personifies the crown. It is equivalent of an entailed estate and passes with the monarchy, being inseparable from it. Today in Commonwealth realm, crown land is considered public land and is a part of the monarch's private estate. So the crown, i.e., the monarch, personifies crown land, and that land which is personified by the monarch who represents the crown is inseparable from it. Okay? It is inseparable from it. Why? Now, most of you are probably saying that's a lie because England way over there. Let's see. Let's see. Let's see. Radical title. Radical title is a concept of English common law that refers to the crown's underlying title to all land held in overseas plantations and colonies. It granted the crown the power to alienate others from the land and to transfer benefits for ownership of the land to itself or others by itself does not grant benefits for ownership. So once again, under the radical title of the crown, it's responsible for the overseeing of all the territories that were called the overseas plantations and colonies. So the land is inseparable from the crown because the crown is personified by the monarch. What they did was take the monarch at the picture. Okay? They took the monarch out the picture and not practice the law of the monarch, which is the common law of England. We just seen that the right to escheatment is in the statute under the common law. We just seen it, right? It says the common law doctrine of bona vacatina should remain viable with respect to unclaimed property. Okay? Under the common law. We must understand that. Under the common law. So if property remains is ceded to the crown under the common law, the king must be there and the common law must be there as well. So for that, we go ahead. New Jersey Revised Statute, Title 46, the title governing property. Certain tenures holdings turn into free and common and soakers, as we read in lieu of the crown and the concept of the crown. Right? It says the tenures of honors, manors, and lands, or hereditaments of an estate of inheritance at the common law, held either of the King of England or any other person or body politic, corporate, or any time before July 4th, 1766, and declared by Section 3 of an act concerning tenures, passed February 18th, 1795, to be turned into holders of free income and soakers from the time of their creation and forever thereafter, and shall continue to be held in free and common soakers and discharged of all the tenures, charges, and answers enumerated in said section 3. Why? Because if the land is not being tenured out, then that means that the king holds it under his radical title because the land is allodial. Let's go back to crown. Though not used this way in all countries that had this system, in England, all rights privileges were ultimately bestowed by the ruler. Land, for instance, was granted by the crown to lords in exchange for fiddle services, and they in turn granted the land to lesser lords. One exception to this was common soakers. Owner of the land held as soakers held it subject to the crown. So as you've seen in the New Jersey by statute 46:3-2, the king held the land and free and common soakers, and the land always remained in what? Free and common soakers. Why? Because the land was abandoned through bona vacatina, which is called the land law of escheatment. Okay? Under the same title, Title 46. When such land becomes ownerless, they are said to escheat, i.e., return directly ownership of the crown, which is called crown land. Bona vacatina is the royal prerogative by which unowned property, primarily unclaimed inheritance, becomes property of the crown. We must comprehend that. So, in actuality, the only thing that you guys have is a right of easement. All right? You only got a right of easement. What is a right of easement? Let's break this down for you. Do ties teach you this? No. Easement is a non-possessory right to use in or enter onto real property of another without possessing it. It's best typified as a right of way which one landowners A may enjoy over the landowner of B. An easement is property rights and type of incorporated property in itself at common law in most jurisdictions. Okay, so this is called a fief. Okay, a feudal tenure. Okay, a right and use of property that you do not what own. You don't own it. Why? Because it's under the authority of what we call eminent domain power. What is eminent domain power? How many of you know that term? None of you. Why? Let's see. Eminent domain power, also known as land acquisition, and land acquisition, compulsory purchase, or eminent domain power only results in the power to escheat. And the only way you got that power is all the heirs dies. And if all the heirs dies, the state don't get it. They just only look after it as a result of it being in their custody. It reverts back to the crown, but the crown is not in play. Why? Because the crown has to be incorporated. All right, which I've done. So it said the eminent domain power or land acquisition or compulsory purchase or resumption compulsory purchase acquisition or expropriation is the power to take private property for public use. Did you hear me? It's the power to take private property for public use. It does not include the power to take or transfer ownership of that private property from one property owner to another. Private property owner without a valid public purposes. This power can be legislative delegated by the state to municipalities, government subdivisions, or even to private persons or corporations when they are authorized to exercise the function of public character, i.e., character. So you don't own it, you can't transfer it. The only thing you can use it is by way of private property. You only can use it. And this is through the eminent domain power of the state. Let's see. And they only got that through prescription. What is prescription? Prescription. Prescription in international law is a sovereignty transfer of a territory by open encroachment by a new sovereign upon the territory for a prolonged period of time, acting as the sovereign without protest or other contest by the original sovereign. It is analogous to the common law doctrine easement by prescription for private real estate. Did you hear me? The doctrine legalized the jure de facto transfer of sovereignty caused in part by the original sovereign extended negligence in or neglect of the area in question. Did everyone comprehend that? I hope you did, because I got to move forward. Let's see here. Now let's show you how they did it. Let me show you how they stole it. This is New Jersey Law Review Commission. This is from New Jersey Law Review Commission. And what they do is look at the statutory language and see if it's unconscionable or is it still needed. And they're trying to say that the laws that protect our estate is no longer needed because those who are heirs to the state don't exist. All right? It says here, this section contains streamlined and consolidated language from the source section as follows. It's taken from 46:3-1, it's taken from 46:3-5, it's taken from 46:3-14, and taken from 46:3-4. Restates the rule against perpetuities, and F is taken from 46:3-9. The phrase fee simple has been used to indicate ordinary title to real estate. It has been substituted for free and common soakage. That's a violation of law. A phrase used in some of the source statutes. The phrase has a number of meanings, but in the context, it is identical to fee simple. So they're trying to say free and common soakage is identical to free and simple, which is a lie. It's also intended as equivalent to allodio, a word used in some older cases meaning form of ownership not subject to any rent, services, or acknowledgement to any superior. Now we know that's a lie because the lolio is when the land is not subject to any type of fee simple conveyance. All right, by way of common recovery. And if that's the case, that means that the land is lolio, which means that it's in the possession of the owner through what we call lottery of season. Let's go back there. Inquisition post mortem. We looked at lottery season. Let's go to season now. All right, right here. Season. Seizure or seizure is a legal concept that denotes the right to legal possession of a thing, usually a fiefdom fee or an estate in land, or you call it cestui que. It is similar but legally separate from the idea of ownership. You hear that? The term is traditionally used in the context of inheritance laws in the form of the son and heir of X has obtained season of his inheritance, and thus it is effectively a term concerned with conveyancing, the right to convey. That's property law. The person holding such a estate is said to be seized of it, i.e., has obtained it, a phrase which commonly appears in inquisition post mortem. The jurors find that X died in seized of the manor of blank. The monarch alone held all land of England by his allodial right, and all his subjects were merely his tenants under various contracts of feudal tenure. It has varied relevance in modern legal system with distinctions between common law and civil law jurisdiction. All right? We must understand that. So if that's the case, if the king held the land under allodial title, if the king held the land on the allodial title, let's see. Let's go to the statute that says the land is allodial. New Jersey says the land is allodial. We all know this. New Jersey by statute, gift, grants, conveyances by the state is allodial. So that means that none of y'all shall have a possession of any estate and land because according to the laws of escheatment, no heirs exist. That's why it went to the state as bond vacatia as prescribed by 46 30B-1 and 9. But under the common law, I have the right to convey the land based upon lottery of season by way of law and not lottery of deed. I did create a deed on the lottery of season by way of lottery of law based upon the land being allodial. It says here, all grants or conveyances made prior to and after July 4th, 1776 of the estate of inheritance by letter patent under the great seal of the state or any manner by the statute, any manner by the state, by the legislature thereof, or by commissioners, pardon, so or agents of the forfeited state or by other lawful and competent authority under the state shall and be remain allodial and not feudal and shall forever be and continue in free pure allodium only forever discharged of all feudal tenures and incidents thereof and all services whatsoever. So that means that the land is allodial. So that means that the land belongs to the king. The king ain't here because it's in what they call an interregnum until we incorporate it. Once we incorporate it, the crown has now revived. It is now revived. Okay? We must comprehend about what's going on. Because the crown never dies. According to Jersey Provincial Council, the crown never died. Okay? Right here. It says it right here. The crown for New Jersey, all right? New Jersey Provincial Council, His Majesty's Council for the Province of New Jersey, which was a royal colony, the length and term of it was indefinite. You hear that? Indefinite. All right? Has always been indefinite, going all the way back to the monarchs, going back to Escheat. Okay? During the lobby of season process, that what they call the twerp and twig ceremony. Okay? The twerp and twig ceremony. We must comprehend that. All right? New Jersey very aware are aware of that. Okay? New Jersey is aware of that. As I come to my closing, let me just prove that. You go right here on Wikipedia, New Jersey courts. It'll tell you right here, common law New Jersey courts, introduction, New Jersey 1947 Constitution creates a court system capable of responding to the needs of citizens and the changes of our society. This is 1947, and it originated from that which was preceded by the 1776 Constitution. How do we know it? Let's just look at it. And closer. New Jersey 1947 Constitution created a court system capable of responding to the needs of New Jersey citizens and to change in the changes in our society for more than 7 decades. New Jersey Supreme Court has gained recognition nationally among the state's highest court for its timely, prudent, and well-conceived innovations to the common law. The common law, like other judicial principles, rise out of court rulings resolving controversies presented to courts by people in search of solutions. So we want a solution. The only way we can find that solution is based on the common law precedents that existed prior to these laws that we are bound by now. In effect, the common law results from judicial decisions resolving from those issues on a case by case. Okay? On a case by case. Origination of the common law. Being one of the original 13 colonies, New Jersey has been strongly influenced by the English law and the Anglo-Saxon traditions. The three branches of government enshrined in New Jersey's Constitution and New Jersey's Constitution, you hear that? U.S. and New Jersey are derived from the English history, and the king was the executive branch, Parliament, the legislative branch, and the court, the judicial branch. It was in the English judiciary that a formal civilized system for resolving disputes and addressing crimes originated among English-speaking people. So if you're English speaking, you must know this history in regards to your nationality as an English national, or unless you just speak in English as a second language. It was the early courts in England that the common law took root and evolved into our current system of court. You hear that? It was in the early courts of England that our common law took root and evolved into the courts that you have today. And the courts that you have today and the judges and the juries that are bound by those courts took an oath to the common law as we know it today, which dates back to the 12th and 13th century and derived from the reign of our ancestor, King Henry II, son of Godfrey V, Count of Anjou, son of Folk, ruler of Jerusalem, which I'm the reincarnation of, going back to King Edward the People, who appoint judges to resolve disputes among his subjects, which is being done today and presently in this day and time. We must understand. How? Let's go to the case law. State versus oldest elevator. Let's look at the case law. All right. Who has the Escheat power? I do. The crown. All right. This is State Otis Elevator, a 1953 case. 1953 case from the Supreme Court of New Jersey. Did you hear that? The Supreme Court of New Jersey. All right. So this is the highest court in the land. And modern use is Escheat signifies the falling of property to the sovereign for want of an owner. And this category embraces not only property which has no owner, but also property which owner or whose owner whereabouts is unknown. Under the common law of England, you hear that word? Common law of England, escheats came to be classified as another branch of the king's ordinary revenue. You hear that? Ordinary revenue. Blackstone commentary states that what was originally an accident of tenure is now an incident of sovereignty. It states the doctrine of escheat at the early common law operated only upon that which was the subject of tenure. Okay? Since it is related to the reversionary right of the Lord to take for one of a tenant was eventually extended to include personal property, tangible and intangible. The principle was a right to take that which belonged to no one was appertaining to the crown as his jure regalia. The crown steps in to take the property because it is vacant. Property described as bona vacatia, i.e., New Jersey by statute, Title 46, colon 30B-9, under the common law, this is where it's stated. It's still valid. Property of the class falls to the crown as a matter of right in the exercise of its sovereign power. And personal estate, that means your estates as well, since you are considered dead in the eyes of law as a result of its seed power of the state. And personal estate, which are allodial by law, which we know that New Jersey is allodial by law, and all things on it belongs to that who owns the land is allodial by law. The king is last heir where there is no kin, because y'all don't exist no more. Y'all want to be Negro Black, Cousin Ethiopian, Moors, and everything else out there. With the tenure abolished, succession is by likely the right, whether the subject of estate is personal estate or real. But you must comprehend. You don't believe this case? Let's get another case. Let's go to state versus bipartisan, Standard versus Standard Oil Company. All right? The same language. State bipartisan Standard Oil Company from who? New Jersey Supreme Court of New Jersey. Okay? Taj, you have no idea about what you're talking about. Okay? No idea about what you're talking about. And modern usage is G6 by the falling away of property for one of the owner. We just read the same thing in Otis Elevator Company. We read the same exact quote all the way from here. We read the same exact quote, so I'm not going to read it again. We're going to go below the quote. Okay? Let's go below the quote. Right here. With the policy of the state superior right under the doctrine of bona vacatina was described by Blackstone as the avoidance of the strife and contention with the mere title of occupancy and apt to create and continue and to provide for the support of public authority in the manner the least burdensome to individuals. You hear that? Blackstone commentaries state that the state has the same dominion over an intangible property that it has over tangible property. Only as custody. You hear that? Let's go right here. Where is it at? Oh, I'm on the wrong case. That's why. All right, let's see. Oh, no, I ain't. I'm on the right one. I think this is it. Hold on. Where is this at? Let me just find it, y'all. I think it's this case. Where is it? I'm gonna find it. Bear with me. It might be the other case. Let me just make sure. Yeah, it might be the new case. Let me see if this is it. Yeah, here we go. All right, sorry about that. There we go. State versus elevator company. Now we just got to read the same thing about the Escheat power of the crown. All right, I'm gonna show you again. We just got finished reading it. Right here. We just got reading this and that other case. The very same quote. We just got finished reading. Okay, from the top to the bottom. Okay, so we're not going to read that again. We're going to go a little bit further down in this case. Go a little further down. It thus appears that an Escheat action is one by which the state comes into court seeking accounting of property for which it is its residual owner and judgment as to its title thereto. So this is the same situation that I, your king, is in on behalf of the crown, and the state comes in as a plaintiff as a result of an interest in property that they don't even know who the hell the owner is. Okay? All right. So they're only doing so because they're assuming that the state has the exceeding power as a result of their power of eminent domain, i.e., prescription, compulsory power. Okay. Let me just show you this diagram real quick. I showed you at my last lesson. I know a lot of you don't pay attention. Involuntary alienation of land. It's just how it's done. Acquisition of sovereignty. I just talked about that. Okay. Acquisition of sovereignty. When a person dies, okay, when the English heirs died, our state became bona vacatia, abandoned. Okay. So the process of that property, which was abandoned, real property, personal property, but we were slaves at that particular time. The land and us as personal property is ceded to what? The state of New Jersey. Okay, it just said it. Property taken by the state of New Jersey. They took it under the eminent domain power called and took the land for public use. Okay? The only way they can do it is through the eminent domain power. Once they did it, they created these fraudulent contracts, which were a heasable contract. And as a result of the encumbrances that they created through easement, because a result of the encumbrance, i.e., tax, federal tax, you wind up in foreclosure, and guess what? They take it right back from you through a process called adverse possession. So you see a diagram right here. Okay? It's involuntary alienation of your land as a result of interstate. Y'all don't want to be who you are. Okay? And I'm only speaking to the reference of the English heirs. No one else has an interest in this estate. Involuntary property can be transferred by involuntary alienation. That is without the owner's consent. The owners, our ancestors who gave us the property, don't know what's going on. They dead and gone. All right, but they left the preservation in by way of what we call operation of law. Such transfer are usually carried out by what? Operation of law, ranging from government condemnation of land for public use for sale of property to delinquent taxes and mortgages liens. These are these contracts that they created as a result of you agreeing to the contract, not knowing that the actual contract were inadmissible as a result of you not knowing contract law. Contract law based upon laws governing frauds of contractual agreements created in writing. We didn't have to go based off that because our contractual agreement based upon the conveyance of our land that was going back to our ancestral time was done by what we call library of law. It was in the law, but no one knows law. Todd Tariq didn't even know the law. He didn't know the twig and twerk ceremony. I know the twig and twerk ceremony, but it's not based upon some deed that you can bring into a court of law and make a claim in interest because the deed is not proof of ownership. It's only an instrument showing conveyance from one party to another. And I bet you 9 times out of 10, neither party are the original owners. Why? Because based upon the statute, it says the land is allodial. Pardon himself. Sorry about that. Okay. All right. So involuntary alienation is to agree to let someone take your estate by doing nothing about it as a result of what they call prescription of sovereignty. Okay? Prescription of sovereignty. All right? Somebody claimed to be the sovereign and they not. So the only person that can challenge that, all right, is a true sovereign. And in order for you to understand a true sovereign, you must understand the terminology associated with sovereignty. Okay? Sovereignty. Let me get my phone right. Acting up. So voluntary alienation is the alienation of property, voluntarily do what they call escheatment. Okay, you see it right there. Do escheatment. No one can deny that. All right. You got voluntary and involuntary. All right. We did both. We voluntary and involuntary gave it up. All right. Our actions show and justify why it was done. Okay. So you must comprehend what's going on as I come to my closing. All right. Let's go back to the case law. So it thus appears that the Escheat action is one by which the state, and we're gonna put New Jersey in there, comes to court seeking an accounting of property of which is the residual owner and a judgment as to its title thereto. The complaint using the language of the statute on the revised statute 2:53-21 alleges that certain property has acceded to the state and seeks discovery and accounting of all such property and the possession or custody of the defendant. Now, we just said that the land is in the custody of the state of New Jersey based on the revised statute. So what the hell are they talking about here? All right, the defendant ain't holding it in custody. The state is holding it in custody, but the state is trying to take it based upon their exceeding power. When the court gonna say y'all got a problem with that, let's read it. It is well recognized that an action such as this in the nature of a accounting the property is brought within the control of the court and constitute a fund in the court within the meaning of Rule 3:54-7b. Let's read it. Having shown that the allowance of counsel fees has always been deemed a matter of procedure in the state, that the sole source of authority for the allowance of counsel fees where there are funds in the court is ruled by 3:54-7, and that there are funds in the court and remains to consider the certain argument advanced by the state, meaning that the power of the state to have the power to exceed. Look what they say. First, it is argued that the rule of the in Westervelt versus Regency, the rule 3:54-7 as the council fees cover the field to the exclusion of all else. The rule of Cox versus Faber states that there is a fund in the court where the court has jurisdiction over the fund or a state. And the rule of Winsbury versus Salisbury states that the rulemaking power of the Supreme Court is not subject to overriding legislation, but is confined to practices, procedures, and administration, and must give way when the state is the party to the action. In such case, it is maintained the legislator may prescribe the procedure, and the such legislatively prescribed procedure may be in conflict with the rule of the court relating to practice, procedures, and administrations, and will override the rule of the court. All right? We can find no basis in law or equity for such a view, but on the contrary, we cannot but regard such a suggestion as fraught with great inconvenience because it will lead to two systems of procedure, one for the ordinary litigation and the other for litigation involving the state. Indeed, in this view, the legislature might prescribe as many different systems of procedure as there are or might be proceedings to which the state is a party, thus defeating the objective of uniformity, simplicity, and flexibility that are the goals of our new procedural system and that is conceded throughout the country have been in large measure achieved here. If this doctrine urged us were accepted, it might even be extended to all criminal trials because the state is necessary a party, such is the case with me. But far more important than the procedural difficulties of a rival or even multiple systems of practice in the procedure is the grave substantive danger of conceding to the state a preferred position in the court as a plaintiff. One of the signal triumphs of the common law as distinguished from continental systems of jurisprudence is that for centuries it has been a recognized principle that everyone is subject to the rule of law and that no man is above or beyond the law, said Braxton, and that the greatest of the early writers of the English common law, Rex non debet et sub hamne set sub deo et sub legat quet le facit regime, means that the king should not be under any man but under the God. But under God and under the law, because the law makes the king. De leticus et constelabilis angelia, angele. Let's read a little bit more before I close out. The rule of the king can do no wrong. That's one. Two, the procedure rules that the king cannot be sued in his own courts, a rule derived from feudal days when the lord cannot be sued in his own court. In England, however, this exception has gradually disappeared. Property has long been revocable from the crown by petitioner rights. Contract obligation enforced against the crown since 1860 with the important exception of the Crown Proceeding Act of 1947, established against the Crown liability in torts as it were a private person of full age and capacity and can be made liable for torts of his service and agents. Okay. All right, so I think we're good on that. So in closing, let's look up jury regalia before we close up. Jury regalia. Jurigalia. Jurigalia, a legal term that denotes belong exclusively to the king, either an essential to sovereignty, jura major or jura essentialia, such as a royal authority, or an accidental jura minora, jura accidentia, such as the hunting, fishing, and mining right. Many sovereigns in the Middle Ages in the later times claimed the right to seize, i.e., season, the revenue of a vacant episcopal see or abbey as a regalia right. So these rights we see under the jure regalia, under the radical title of the king, based upon overseas possession, based upon the common law of England, based upon the power of the crown to escheat. When there's interstate, meaning there are no heirs, such as this case, then the power had to be conveyed to the king when the king come back, because that's what the commissioners, i.e., freeholders, took an oath to do under the 1776 Constitution. Okay, so with that, we must understand and comprehend in regards to the power of Escheat. Okay, in regards to the power of Escheat. The new Escheat doctrine, as prescribed by New Jersey Revised Statute, New Jersey Revised Statute, Title 46, Colon 30B, it clearly says, and I repeat, y'all, when property is subject to the custody of the state of New Jersey, unless otherwise provided in chapter or by the other statutes of the state. Second. Of the state, property is subject to the custody of the state as unclaimed property. If the condition raising a presumption of the abandonment under Article 2 and 5 through 16 of this chapter and are satisfied, and the condition under Rule 10, under Section 10 of Title 46 of Section 30 are satisfied, the common law doctrine of bona vacatina should remain viable. Once again, the common law doctrine of bona vacatina to remain viable with respect to unclaimed property, and that's called the power of escheatment of the king under the common law, and that was reserved in New Jersey by Statute 46, colon 3-2, as I close on that. New Jersey by Statute 2023, certain tenures, i.e. federal tenures, now turned in free and common soakers, because that is the purpose and the concept of why the crown originated. Okay? We must comprehend that. Majority probably you won't, but hey, I did my job. So it says in closing, the tenures of honors, manors, lands, tenements, meaning holdings, or hereditaments, meaning that of a inheritance, whether it was left by a will or by some type of operation of law, or in the state of inheritance at the common law, held either of the King of England or any other person as representative for the King of England, operating under the body of politics for the King of England, and that body of politics was Parliament, based upon the incorporation of our certificate of incorporation, which incorporated us with the right of our predecessor, i.e., our predecessor corporation, i.e., corporation. So, and this was done and paramount as a result of what was done after the charter were given out. And as a result of that, our ancestors had to create operational law statutes to null and void it, and that was preserved in the statute that we're reading now, because it clearly says that before the time and after July 4th, 1776, that's the day y'all declared your independence, and declared by Section 3, an act entitled an Act concerning tenures, passed February 18th, 1795. That's when the United States declared their constitution, declared their a body politic in 1790, is to return to holding and free and calm Minnesota from the time of the creation and forever. So whatever the United States and the states got, they hold it for the crown, and the crown is represented by me by way of what we call the corporation. So because I personify the crown through my incorporation. So with that, I hope you all can comprehend, and not just comprehend, understand. If you understand, the main thing for you to do right now is remember. Okay? Remember, all right? I mean, there's a lot of things on TV right now that you can be viewing. But if you are viewing anything outside of this, you definitely need to change the channel. Okay? Especially if you're watching House for Awakening the Mind, because Todd Tariq didn't have a clue about the Twig and Turf ceremony, and that's how our possession was created through the Twig and Turf ceremony, going back to Asso Stone. Asso Stone means noble stone. Okay, son of Alpha the Great. All right, so we must comprehend that I have preserved our estate and is intact and cannot be separated from me. The only thing that needs to be done is being distributed out to those heirs, okay, of the estate by way of what we call land tingers. All right, so with that, I'm going to greet you and leave you as I always, and that's in peace and love.